some of us who are not so familiar with our work, just maybe I could take a few minutes just to introduce our organization a bit, so that we put into context the kind of work that we do. Article 19 is an international organization which is international, with its international office based in London. Our mandate, we work on freedom of expression issues and access to information. We defend both of these rights, and we are an organization which has been working on these rights for the last 30 years. Recent developments in the last decade has been the successful setting up or operations in 6 different regions. We now have regional offices in East Africa, in Kenya, in South America, in Brazil, in Central America, in Mexico, and in South Asia, which is run from Dhaka, Bangladesh. And also we have our European regional office, which is operated from London. These offices have meant that the hardcore legal analysis and principles on which Article 19 has been so famous for has meant that they have been translated into regional context and and parallelly setting up work with the journalist communities in different parts of the world. Not only journalist communities, we also now work with online activists and on various other activists, environmental protection activists and so on. Article 19 Bangladesh and South Asia office started in 2007 September and has been operating since the last 7 years. I joined the organization since the setting up of the Dhaka, Bangladesh office. It has now grown into a South Asia office. This kind of puts into context some of the work that we do in Bangladesh. We work with journalist networks all over the country, protecting freedom of expression, looking at safety and security issues of journalists and the print media, also more and more for online activists. Also, we have a large program which works on the safety and security of women journalists in Bangladesh. Also, side by side, we have projects on access to information. But where we draw some of the work that we draw from are the legal analysis that Article 19 puts together globally. And the Rabat plan of action is one such example of a legal analysis. For those of you, I guess the paper, the Rabat plan of action was in the packet, so many of you might have had the opportunity to go through it. This is if we start, it's a very, it is about indivisibility of articles in the ICCPR and UDHR. Article 19, as we know, stands for that everyone should have the right to seek, receive, and impart information without fear and in various medium, regardless of frontiers. Whereas at the same breath, Article 20 of the ICCPR recommends or requires states to legislate to prohibit advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. So at the same breath, while we're talking, Article 19 gives a broad-based rights platform. Article 20 requires states, the same states, to legislate to prevent or prohibit expression, an expression which advocates national, religious, and racial hatred, and at the same time constitutes incitement to discrimination, hostility, or violence. Now, there are two critical words here. One is advocacy. The second terminology is incitement, and so that means that where there is a hate speech based on national identity issues, racial identity issues, or based on religion, such expression needs to be prohibited. And so Article 19's position always has been that state parties should legislate to prohibit insightful hate speech. particularly in relation to advocacy, national or religious hatred. Let us just to give it a bit of hate speech is a very wide terminology, but the Rabat Plan of Action focuses only on hate speech, which deals with national, racial, or religious hatred. There are other types of discriminations, other types of expression which it does not deal with. So we need to just look at the boundaries of what the Rabat Plan of Action is saying. Just to give a bit of context, that how did this Rabat Plan of Action came into being? That Article 19, for the last 4 years, has been working on a set of principles that require that state parties should follow when they are putting together legislations. And that was then we were working very closely with the Office of the United Nations High Commissioner, OHCHR, and then based on Article 19 recommendations and other recommendations, 4 such consultations took place starting from 2011. One was in Vienna, the other one was in Africa, the other another regional conference for Asia and the Pacific was held in Bangkok. The one for Americas was held in Santiago, Chile, on 12th and 13th October 2011. And then finally, in 2012, the recommendations from all of these regional consultations were discussed in Morocco, Rabat, on 4th and 5th October 2012, where the final expert workshop took place, and then emerged the Rabat Plan of Action, emerged from there. What is the context for the Rabat Plan of Action? And we've seen that in the last decades that many conflicts have had components of hate speech or hatred towards different racial identities or religious identities, and that and that's the kind of political context within which this discussion has taken place. And in terms of legislation, we've seen that national legislations in many places, mostly their nation states have not forwarded legislation to curtail hate speech, basically. And where they have had legislation, they have used wide-ranging terminologies, which can lead to abusive and arbitrary use to curtail freedom of expression, and also, for example, and if we look at the South Asia context, and I will invite our friends from different countries to shed a bit more light on that. My understanding of the South Asia context is that there is very little legislation to prevent hate speech as such, but in existing laws there are penal codes have certain provisions which prevent incitement to religious hatred. But these are kind of ad hoc legislations. There's no comprehensive legislation in any of these countries which actually requires obliges the state to prevent hate speech. But I understand that in India, specific legislation is being proposed, and that calls for discussion. What does the Rabat Plan of Action actually tell us? It's basically the principle on which it is based is that freedom of expression, for exercising freedom of religion, freedom of expression is essential because it promotes diverse conversations, vibrant discussions on religious issues which require interpretations, and that critical discussion is essential to the discussion of freedom of religion. And for that, there should be a space where freedom of religion issues can be vibrantly discussed. And within this context, if state parties were to legislate, then we believe, or the Rabat Plan of Action advocates that there should be certain guidelines based on which state parties should undertake legislation. And they should follow certain principles, or else the arbitrary or abusive use, we open doors for arbitrary and abusive use. And to start with, the Rabat Plan of Action very clearly states that all expressions should be categorized broadly into three categories. There would be three types of expressions. One type of expression which constitute criminal offense, and the second type of expression is that it does not actually constitute criminally punishable offense, but may justify civil or administrative sanctions, but basically expressions which does not give rise to criminal or civil action. And the third category are those which raise concern in terms of tolerance, civility and respect for rights of others. So three categories, we should categorize expressions. The third type of expression is basically telling states that you should be more tolerant, that there may be times when statements or expression will raise concerns in terms of civility or respect for rights of others, but there should be no measures, no criminal measures, nor any sanctions advocated for that type of expression. The second principle that the Rabat principle advocates is that states we have seen that where legislation has been there, that states are very loosely used terminologies, in defining hostility, in defining violence, or in defining discrimination. So it's recommending, Rabat Plan of Action recommends that where legislation is going to be formulated, it should strictly follow within the principles of Article 22 of the ICCPR, and furthermore, on certain principles which is called the Camden principles. These were principles advocated by Article 19. It's now part of legal jurisprudence, and they have and Article 12 of the Camden principles provides very clear definitions on some of these terminologies. Let me give you an example, which would, for example, Article 12 defines the terms hatred and hostility refer to intense and irrational emotions of opprobrium, enmity, and detestation towards the target group. The term advocacy, once again, it's a very open term, but it's defined, the term advocacy is to be understood as requiring an intention to promote hatred publicly towards the target group. The term incitement refers to statements about national, racial, or religious groups which create an imminent risk of discrimination, hostility, or violence against persons belonging to those groups. So it continues. So Article 12 of the Camden Principles provides very specific definitions, and the Rabat Plan of Action requires that state legislation should follow the similar definitions. The third, in terms of advocacy, as I have said, that it's not encompassing everything and everything, but anything and everything. It is only advocacy of national, racial, or religious hatred that constitutes incitement to discriminate, hostility and violence. That's the scope, that should be the scope of any legislation. And we're not going to deal with all other kinds of hate speech. The fourth principle also is that states should ensure that there is a three-part test for restriction of freedom of expression. And this restriction comes from Article 19. Article 19 also requires that there should be freedom of expression, but expression can be limited or prohibited only in three cases. There's a three-part test which says that restrictions can be made if provided by law. Restrictions can be made when they should be very narrowly defined to give a legitimate interest, and such restrictions should be necessary to pursue that legitimate interest. So the Rabat Plan of Action also recommends that if restrictions have to be made, they have to follow this three-part test, that there should be legality, proportionality, and necessity. And it also, Rabat Plan of Action also advocates that states that have blasphemy laws should repeal these laws because they have stifling impact on the enjoyment of freedom of religion. So it absolutely does not advocate blasphemy laws and calls for repeal of all blasphemy laws, because it sets one set of populations against another set of populations. Also, the Rabat Plan of Action, based on the analysis that it did in the consultations, found that where incitement cases were brought before the judiciary, there needs to be a detailed discussion of the judiciary to understand or to come to a position where incitement has happened. And then it calls for that and for that we need an independent judiciary. So a state party should ensure that the judiciary is independent and that interpretation is fostered, interpretation on incitement or terminology should be fostered. And based on what? This is one of the most critical part of the Rabat plan of action, that it gives guidelines to the judiciary to understand or to come to a conclusion where incitement has happened. And it's a 6-part test which suggests that the first thing is that when you're looking at a statement, you should apply the test of context. That context is of great importance when assessing whether particular statements are likely to incite or discriminate. Analysis of the context should place the speech act within the social and political context prevalent at the time the speech was made and disseminated. Speaker, the position of the speaker, status of the speaker in the society should be considered. Now, specifically, the individuals or organizations standing in context of the audience to which the speech is directed. Obviously, a one-to-one conversation with somebody, but if somebody's speaking on if I'm speaking on behalf of Article 19, that would have a different weight than if I'm speaking on my own. So the status of the speaker needs to be considered when deciding whether there has been incitement or not. Intent. Article 20 of the ICPPR requires intent. So negligent or recklessness are insufficient to meet the standard of Article 20. So when we are saying advocacy or incitement, mere distribution or circulation of kind of leaflets does not mean advocacy or incitement. In this, it requires much more. So the intent needs to be looked at as well. Content or form, of course, the focus should be content analysis should be done, and you should look at the form, style, nature of the arguments deployed, and the courts deployed in the speech at issue or in balance struck between arguments deployed. So the 4th test would be the content of the form, and the 5th is extent of the speech, of course, the size of the speech, the means of dissemination, frequency of that speech. All of that will have bearing on whether it has been insightful or not. And of course then likelihood and including imminence. What exactly is the likelihood to harm from that speech? So all of these 6 tests needs to be applied by the judiciary to come to a conclusion whether incitement has happened or not. And the Rabat plan of action is very clearly and in voluminous terms have given guidance to the judiciary. So it does not leave open for the judiciary to make its own interpretation. So it provides actual standards. So country by country, if there are legislations, judiciaries would need to apply these tests. So at the moment what is happening is it's left up to the judiciary to decide whether incitement has happened or not. So, and finally, of course, the Rabat plan of action is categorical, that criminal sanctions related to unlawful expression should be seen as a last resort. And should only be applied strictly in justifiable situations. It basically calls for civil sanctions, remedies which should be considered, including pecuniary or non-pecuniary damages. Administrative sanctions could be there. But finally, it calls for an independent media, independent and pluralistic media which promotes diversity of views and opinions. It requires civil society organizations. It requires the state, people in influential positions, politicians, to promote divergence of views and different voices. Now, having talked about the Rabat plan of action, one might say, okay, it's all about what the state should do to prevent. Okay, all right. Yeah. So I'll come to it later. That how is it relevant for freedom of the press, and why should why should we educate journalists, and journalists should learn about this? I think I'll close it here and leave it open for questions.
Yes. Isn't that